on this morning's Ag Issues program. And it is a pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. And by the way, if you want to follow on Twitter, great follow as well, at Washburn, WALTR, at Washburn, WALTR. And Roger joins us in studio this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
Well,
fine.
As always, appreciate you coming on to the program. And, well, let's talk as far as the issues are concerned. And, of course, a big one right now is what we see or what we may not see, or how things are going as far as the Navigable Waters Protection Rule is concerned, a.k.a. WOTUS, Waters of the U.S., whatever name you would like to put on it. But this has been going on, and it has been controversial on both sides for many, many years. So a very general question, but I think one that probably needs to be discussed. What are we seeing as far as the current status of the law is concerned on this particular issue? Because obviously of its importance to so many farmers, ranchers, and landowners. Oh,
Greg, this has been a huge issue for probably 40 years in the courts. Of course, the Clean Water Act amendments back in 1972, with that, the Congress didn't give us a clear definition of what a water of the United States is. So they never really defined the boundaries of federal jurisdiction over waters of the United States, or even define what a water of the United States is, which gives the federal government jurisdiction. So the courts have struggled with this, and of course you've got bureaucracies that try to step as far out as they possibly can to grab as much control as they possibly can, and a lot of that is over private property. And that's where farmers and ranchers get concerned. If I've got a dry creek stream bed, say in southwest Kansas, that has water in it maybe a couple of weeks out of the year, do the feds assert jurisdiction over that such that I can't farm it?
Which there are many.
Oh, yeah. I could cite you the craziest examples in court cases. There was a case at the trial court level. It never was a published opinion, but at the trial court level in Missouri about 35 years ago, where the government witnesses, when asked by the attorneys for the other side, was they were asserting jurisdiction over what was a dry field. And they said if this were a baseball field and the question was, and the batter stepped in the batter's box and banged his cleats with the bat and soil dropped off of his cleats onto the plate, would you assert jurisdiction over that? And the answer was yes. I mean, that's how crazy some of this gets. And so the definitions are important, and Congress often does this. They'll come up with a policy, and then they'll leave the finer details to the administrative agencies. Well, that works fine when you have administrative agencies that follow processes and publish rules and get public comment and listen to those public comments and stay within the general guidelines of what the Congress has intended and what the courts later have said.
Right.
So this has gone back and forth. And to get to your question, where are we at now with this? Of course, the Obama administration had their own rule. It was a very expansive rule. But what's kicking off all of this were a couple of Supreme Court decisions only about 20 years ago. Let's just put it that way. They were about 5 years apart. The Swank opinion, the Solid Waste Agency of Cook County, of northern Cook County in the Chicago area, that involved a landfill operation. And that gave us one definition of what a WOTUS is. And then a few years later, about 5 years later, the Rapanos decision, I've heard that pronounced both ways, and I'm not sure which is correct, gave us another attempt at a definition. But unfortunately, the Supreme Court, particularly in Rapanos, didn't come up with solid guidelines. In fact, there were 5 opinions out of that court case, and the plurality opinion was written by Justice Kennedy, and that's what the lower courts have tried to follow. But the district courts had extreme trouble trying to figure out what the appropriate test was for determining federal jurisdiction of a wetland coming out of what the Supreme Court said. So we couldn't even get clear guidance out of the Supreme Court on this.
Just one thing on that. To get 5 different written opinions That's unheard of in this.
Out of 9 justices.
Out of 9 justices.
In one case.
Yeah, exactly.
And so you can see the confusion. They're confused about it. We can't even get the Supreme Court to lay a marker down on this. And so the Obama administration came in, and frankly, the EPA at that time, under that set of thought that they had, took a very expansive view. They took and used what the Supreme Court laid down and interpreted that in the most broad terms that they possibly could. And as you know, agriculture went nuts about that. That was ditch the rule campaign, and it was asserting jurisdiction over dry streams, all types of farming activities, ditches, those types of things could be impacted by that. Well, the Trump administration came in and said, well, let's look at all of these administrative rules that are out there, not just EPA rules, but all administrative agency rules, and let's cut back where we can cut back, and let's give clarity where we can give clarity. And so they came up with their own rule. And, of course, the Obama rule had been litigated extensively, and then the Trump administration replaced it, and now that's tied up in litigation. And so that kind of is where we're at right now. We've had another case in South Carolina most recently, just a couple of weeks ago, where the court didn't vacate the Trump administration rule. And I've seen some articles where agriculture was real happy about that, but I would just caution that was by design. They didn't want the rule vacated because the EPA knew if the rule was vacated and you put the Obama rule back in place, they would have to then defend that in court while they're trying to write their own rule. So they said just let that be, let it go. And what they're doing right now in the current administration is they're writing another rule to eventually replace the Trump rule. Now, that'll have to go through the notice and comment procedure, the Administrative Procedure Act, so that's down the road a ways. But that's what's going on, is the Trump rule will continue to be litigated. That's the Navigable Water Protection Rule, right. NWPR. And while that's being litigated, the current administration is writing their own rule to replace that. So the Trump rule is in place everywhere. It's not been vacated by these recent court decisions, but the current administration is aiming to replace it.
And we don't know this, but some would say, you know, the current administration may go back to WOTUS version 2.
Oh, we know that.
In some aspects, yeah.
We know that, yes.
Yeah.
That's what's going to happen. It'll be a much more expansive rule.
But this isn't, I mean, and it's hard to judge how long this is going to take because obviously it's at the speed of whatever the administration / EPA / Army Corps of Engineers, which just shows how many layers, I guess, are in here when you want to rewrite something like this.
Well, that's another thing about this. You have the EPA and the U.S. Army Corps of Engineers that have, in many instances, joint jurisdiction. So they're both involved in writing various aspects of the rule. Plus, you have the Administrative Procedures Act that the agencies have to follow. What that means is once they write the rule, they have to give notice of the rule, set a hearing, provide 90 days for public comment before that, then have the hearing and take those comments into consideration and maybe rewrite it based on those comments and go through the process until they get it refined and finished and then published in the Federal Register, and then the lawsuits can begin again.
Which
they will.
Yeah, and they will, but it's like when the WOTUS came down, oh, God, I don't know, probably hundreds of thousands of comments that were taking place. A lot of them, like you said, coordinated by agriculture to talk about that, too.
Yeah, and while this is going on the federal side with respect to the Navigable Waters Protection Rule and WOTUS and all of that, we have over on this side, remember, farmers also deal with Swamp Buster. That's a USDA program. So that's not Army Corps of Engineers and EPA. That's USDA. And at the same time, right now, Swamp Buster is being challenged constitutionally in federal court. So that's going on, too. That's coming from a South Dakota farmer that is challenging Swamp Buster on constitutional grounds.
Which is a whole different program that we could have on that.
Yeah. Well, we always have plenty of things to talk about. People ask me, do you have enough content to come up with your daily programs? And I just kind of chuckle. Enough content?
Yeah.
Yeah.
Let's see. This, and you're on page 6, and by the time you do that,
right.
It's like, yeah, I think so.
So there's a lot of stuff going on in the courts right now that ag is concerned about with respect to water, Swamp Buster, as well as the whole navigable waters of the U.S. issue.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. I don't get to ask you this very often, but for issues like WOTUS and updates you provide, you've got your daily blog they can go to as well?
Yeah, and I just wrote an article on this whole water issue on the blog last week, so it's available there.
Through the Washburn Law website?
Yeah, through my website,
or through your
which is washburnlaw.edu/Walter, WALTR, or they can just do an internet search for Washburn Walter, WALTR.
Okay.
No E in there.
But just wanted to make sure if people want to keep up to date with that, because it's obviously going to be ever-changing throughout that, too. All right, let's get to a couple of other issues. Let's go over to the state of Missouri, talking about hoop buildings as farm machinery and equipment in the state of Missouri.
Yeah, this is a private letter ruling from the Department of Revenue in Missouri, and normally I don't talk too much about state-specific type things, but this is instructive, I think, on the overall tax issue, because this has been an issue for us from a federal income tax standpoint, and I'll get to this in a second, but what is a hoop building for tax purposes? Is it a farm building? Is it a single-purpose agricultural or horticultural structure? What is it? And we care about that because for depreciation purposes, it's classified differently. If it is a building, then we can't take expense method depreciation on that, so we can't perhaps write the whole thing off in the first year unless we use bonus depreciation on it. But it really matters. Now, this is another one of these areas we're talking about the definition of waters of the United States. Congress didn't define that. Well, they also didn't define what a hoop building is in the tax code. And so it's left up to the IRS to tell us, and IRS has never really told us what a hoop building is. Now, for those that are listening that are wondering what in the world is a hoop building, you've probably seen them. They look like a half circle or a semicircle that's covered with tarp, and often it's used to feed livestock out of, or store the RV. We see that a lot, too.
Exactly.
And by the way, if you're listening and you're under audit from IRS and the agent's going to come out to the farm, get your RV out of the hoop building before they come out to the farm. That's going to raise some other issues. But if we're arguing it's a single-purpose ag structure, my point is use it for one purpose. That really means something from a tax code. Well, we don't have a set definition of what these things are for federal tax purposes, but we got a little bit of insight from the state of Missouri here, and I find this interesting. Now, this is not income tax. This is sales and use tax. But the way the state looks at this can be instructive to us, perhaps on the federal tax issue, at least and it gives you an argument if you're a Missouri farmer. But what you had is a seller of hoop buildings, and these are permanent nature, and they can be used, of course, for livestock purposes, and they can be used during multiple livestock production cycles. Well, the Missouri Department of Revenue said that if a buyer used a hoop building exclusively, solely, and directly for raising livestock for ultimate sale at retail, then the hoop building constitutes farm machinery and equipment. So if it's used for livestock, it's farm machinery and equipment. However, because the statute, just like the Kansas statute, says if you buy something and you're going to use it directly in agricultural production, it's exempt from sales and use tax. Okay, they said it is an ag equipment, farm machinery equipment, if it's used for livestock production, but not to store grain. Because the grain storage is the building, if it's storing grain, is not used in the production of crops. So grain storage, they said, is not an agricultural purpose. Neither is storage of machinery and equipment. So if it's used as a storage facility, it's not used in direct production of agricultural commodities. If it's used to feed out livestock, it is. Now that's interesting, at least to me and tax nerds. That's interesting, the distinction that they make. We would think that if I'm using it to store my farm machinery, my grain, that's an ag function. And for federal income tax purposes, that would indicate perhaps that it could be a single-purpose agricultural structure if that's the only purpose I'm using it for, and so we would get the 10-year classification for depreciation purposes. On sales tax, the state, and I think Kansas would say the same thing, direct production is required. So if I buy something and I'm going to use it directly in the production of crops or livestock, then it's sales and use tax exempt. And I think Missouri's probably right here based on their underlying statute. And I think for Kansas listeners, I would expect Kansas Department of Revenue would do the same thing. In fact, they see these types of things, and, well, they may be listening this morning, and they would probably take that same position too. So I'm not surprised by it, but it is instructive, and it's kind of tricky. A lot of farmers are not thinking that. They'll think, well, if I store my crops in there, that's an ag purpose. Not necessarily. If you have to have direct production, and you do under the Kansas statute as well as the Missouri one.
Another tax issue, Roger, we want to talk about is your tax, quote, home, end quote, is at issue. And you've got a specific case here that goes into that.
Yeah, this is a Colorado case out of the tax court just last week. And this is an issue, Greg, that's come up a lot more, particularly in the past year and a half with the virus and people doing independent contractor work and work from home and all these types of things. But we see it in the gig economy, too. And you may have a farmer that drives truck during the winter months, and they may have various jobs here and there and all over the place that they're doing for various people. Here you have a licensed union journeyman electrician, and he owned a trailer home and a rental property in Colorado. So he lives in Colorado, has his membership in the local union near his home, which gives him priority status for jobs in that area, but the work dried up, and so he takes jobs in Wyoming and elsewhere in Colorado, claims a whole bunch of travel expenses, meals, lodging, those types of things, and writes them off. And the IRS said, no, you weren't really away from home. They'll give you a deduction if you have duplicative expenses, if you're traveling away from your home, but it depends on how long you are working those jobs. And if you're just in and out, you can get travel expenses. If you're there for too long, that then becomes your home, and you're not away from your home to get travel expenses while you're away from your home, because you're not. And his work consisted of a whole bunch of temporary jobs. Each lasted no more than a few months. So he didn't have, they said, well, you didn't really have a principal place of business during the tax year. You're still paying the mortgage on your Colorado home. You've got a lot of ties to that area. And so for some instances, on some of his jobs, he was determined to be away from home because he met all of these sub-tests. For other instances, he wasn't. And even for some where they said, we would give you some travel-related deductions, he didn't substantiate them. So that's the other key here. We're only going to get deductions to the extent we can prove we're entitled to those deductions. So we have to keep good books and records, particularly on these things associated with meals and lodging and vehicle expense. Write things down, take detailed notes, keep your receipts, keep your invoices, and that'll help you. But the tax home issue is a tricky issue. It's hard for my students to understand. Tax home, it's just weird. It's tax home, but it's not your home. So you really have to play with this a lot to get it straight in your mind what this is.
And as you said, you expect to see a lot more of these type cases throughout, probably even throughout the rest of 2021.
Well, and I think going forward, too, I think in some respects the economy has changed, and we're going to see a lot more of people doing these types of things.
All right, Roger, we're out of time, but as always, appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.